Okay, I think we're streaming. Okay, we're just gonna do this again. Uh, some multiple choice questions. I haven't done them in a while. I have only been doing like practice exams, which have been good. However, my last one that I did last week was not my worst score because I've gotten that score before, but I think it's because I stopped drilling these multiple choice ones. So we're just gonna do it. And I have Mr. Beast right here. This is Undertale, but I assure you, it's just saying Mr. Beast over and over again. See, Mister. Okay, we're good. Let's see. There's no applicable statute. Is the niece likely to prevail? A woman died testate. In her will, she devised a farm she owned to her husband for life, remainder to her niece. Her will did not specify the duties of the husband and the niece with regard to maintenance and expenses related to the farm. The husband took sole possession of the farm. Remainder is in the niece. This is important. Did not farm the land and did not rent to the third person, although the fair rental value was substantial. So there's no income. For 2 years in a row after the woman died, the county assessor sent the tax bills to the niece, but the niece did not pay the bills because she and the husband could not agree on who should pay them. Finally, the niece paid the taxes to avoid tax foreclosure. The niece then sued her husband for reimbursement of 2 years worth of property taxes and asked, okay, here's the thing. If you own the land in a life estate, you don't have to pay property taxes for some reason unless you're getting some value, which is like renting it out or living there. Does it say that he lives there? Or she devised the farm, niece with regard to maintenance of the expenses of the farm. Husband took sole possession of the farm, did not farm the land, and did not rent. Although... so if he didn't get any value or didn't live there, then the niece won't prevail. No, because the remainder man is solely responsible for it. No, because the county essentially sent the bills to this. No, because the woman's will was silent on the responsibility. Yes, because the niece paid obligation that was the sole tenant responsibility. I think it's no, but I don't like any of these reasons. No, because the remainder men are solely responsible for the payment of property taxes. That's not true. No, because the county assessor sent the bills to the niece. I don't freaking know what that is. County assessor sent the tax bills to the niece. The woman's will was silent on responsibility. Okay, I'm going to say it was silent, so I was going to take the default rule to the statute, which is like you don't have to. It could be D, though, because I'm wrong. Why is it freaking D? In the absence of contrary direction in the document creating the life estate, the only limitation on the duties of the life tenant had no duty to expend more than the income that could be generated because the fair rental value of the event limitation does not apply. If the remainder man does pay any taxes during the life tenancy, he or she is entitled to judgment. What? In the absence of contrary direction in the document creating the life estate, in this case the will, it is the duty of the life tenant to pay all general property taxes that accrue. Okay, there's definitely one that you don't have to pay. Is it income? It's income tax. It was not an income tax. No, that doesn't make sense. I don't freaking know. I need to review that. Because the fair rental value of the farmland was substantial, this limitation, there's only limitation on this duty is that the life tenant has no duty to expend more than the income could be generated on the land. Maybe it is an income tax? I don't freaking know. Property tax. I need to review that. Okay, it's D. I should have processed elimination because I didn't like any of these no reasons. Oh well. Live and learn. We're off to a great start. Recently, the cousin learned about the friend's deed and possession, immediately recorded her deed, and sued the friend for possession to quiet title. The friend then recorded the deed and raised all available defenses. For whom is the court likely to decide? A man conveyed land by quitclaim deed as a gift to his cousin, who did not then record the deed or take possession of the land. Okay, so the cousin has the land. Well, didn't take to possession, but it's his, right? 6 months later, when the man was still in possession, this guy, he conveyed the land by quitclaim deed as a gift to a friend who knew nothing of the deed to the cousin. The friend did not record his deed. The man then vacated, and the friend took possession. Okay, so the friend's in now. The recording act of the jurisdiction provides as follows: no unrecorded conveyance or mortgage of property shall be good against any subsequent purchases for value without notice. So it's a race notice jurisdiction. So the first to record is going to be the winner. Recently, the cousin learned about the friend's deed in possession, immediately recorded her deed, bada bing, bada boom, and sued the friend for possession and to quiet title. How many years have passed? The friend then recorded his deed and raised all available defenses. For whom is the court likely to decide? 6 months later. Hasn't been years, right? Yeah, it doesn't. Okay, it's gonna be the cousin because he recorded first. Oh, huh? Wait. Oh, and the friend was not a purchaser. Oh no, that's true. As a gift? No, BFP doesn't apply. It doesn't apply because he didn't pay for value. Of course. I should have read. Oh well. Should the court grant the truck driver's motion? We're off to a great start. A garbage worker, a citizen of state A, sued a truck driver, citizen of state B, in federal court in state B. Garbage worker is seeking $125,000 as compensation for injuries suffering in a car accident occurred in state A. But then B, state B law does not permit a court to order plaintiffs to submit to an examination by physicians, but state A law does. The federal rules of civil procedure authorize courts to order physical examination by licensed examiner. The truck driver has filed a motion challenging the alleged injuries and requests the court order a garbage worker to submit. Okay, so it's like so it's diversity, right? I think it's gonna apply state B law. And what does state B law do? State B law does not permit a court to order plaintiffs to submit to an examination. Okay, so no. And here's moving a motion to submit. No. State B law applies, I'm pretty sure. But I think this is a procedural thingy. Huh. Oh, I'm off to a great start. This is a diversity case with a specific federal procedural rule on point that authorizes the court to order the examination. Alright, let's write that down. I should just, like, don't save. Alright. We are off to a fantastic start. Have we gotten any of them right, dude? Ugh. I thought I was good on these, but turns out I'm just mid. In Erie decision, the U.S. court held that a federal court sitting in diversity must apply state substantive law. This includes state conflict of rules. For all procedures, a federal court sitting in diversity must apply federal procedural laws. In Sibach v. Wilson, the Supreme Court held that ordering a party submit to a physical or mental evaluation is a federal procedural law. Is applicable only in certain narrow circumstances. Generally, where a party's mental. Okay, the issue here is whether the truck driver is. Okay, I'm just gonna say, CIFPRO, substantive versus procedural. Mental and physical examinations are a procedural matter, so they are governed by FRCP. Oh, we are off to a fantastic start. One evening, a customer drove to the supermarket to see about a special on turkeys that the supermarket was advertising. She decided that the turkeys were too large and left the store without purchasing anything. In the parking lot, she was attacked by an unknown man. Oh, Jesus. If the customer sues the supermarket, the result should be for... A supermarket is in a section of town where there are sometimes street fights and where pedestrians are occasionally the victims of pickpockets and muggers. In recognition of the unusual number of robberies in the area, the supermarket posted signs in the store that read, "Warning, there are pickpockets and muggers at work in this part of the city. The supermarket is not responsible for the acts of criminals." Other than posting the signs, the supermarket took no other precautions to prevent criminal activity on the premises. This is a tricky one. See essential turkeys. Customer. Sounds like a premise liability question. Plaintiff because the supermarket failed to take reasonable steps to protect customers against a criminal attack in its parking lot. Plaintiff because the supermarket liable harm to business invitees. Because the warning signs were visible to the customer. I don't think it's that. I think it might be this. Because I think criminal act cuts off the chain of causation, right? Oh, okay, I'm a terrible person. Plaintiff because the supermarket failed to take reasonable. The supermarket had a duty to do more than post a warning. The fact that it was aware of ongoing crimes in the market meant that it had a duty to take reasonable affirmative steps. The actual cause, although this does not save the supermarket from liability, as stated above, the supermarket had a duty to exercise reasonable care. An invitee is a person who enters on the premises in response to express and replied invitation of the landowner, including those who enter for purpose connected with the business or other interests of the landowner. Landowner owes an invitee a general duty to use reasonable and ordinary care. Situation involving tortious acts of third person, an owner of a business may still have a duty to exercise reasonable care, including the requirement to take reasonable security measures to prevent attacks or thefts against customer. Thus, a duty to warn in this scenario will not be sufficient. The landowner will likely have to take affirmative steps to prevent the known danger from causing harm. A is correct. The plaintiff should prevail because the supermarket had a duty to take reasonable steps to make the conditions on its premises indoors and outdoors reasonably safe. It must conduct active operations with reasonable care for the presence of invitees, and under limited circumstances, use your customers against foreseeable. This is okay, so it's foreseeable. That's like the whole thing. Man, we're off to a wonderful start. We're going 4-4, I think. His claim is a defendant was arrested in the victim's apartment after her neighbors had reported sounds of a struggle, and the police arrived to find the defendant bent over the victim's prostrate body. The victim was rushed to the hospital where she lapsed into a coma. Despite the explanation that he was trying to revive the victim after she suddenly collapsed, the defendant was charged with attempted. That the attempted is like significant. After a neighbor informed the police that she heard the victim sobbing, "No, please let me alone." His claim is, at trial, the forensic evidence was inconclusive. The jury acquitted the defendant, but convicted him of assault. While he was serving his sentence for assault, the victim, who had never recovered from the coma, died. The defendant was then indicted and then charged on a felony murder. In this common law jurisdiction, there is no statute that prevents a prosecutor from proceeding in this manner. But the defendant argued that a second trial for it. Okay, I think his claim is incorrect because it was the charge for the assault, but now it's like a new one, it's felony murder. So in him saying that it's a violation of double jeopardy clause is incorrect because the victim had not died at the time for trial, was not placed in jeopardy for murder. I think it's that one. What? Oh, of course. Wait. What? I'm doing so poorly. Assault at common law is not a felony and cannot be used for the basis of a felony murder charge. Okay. Can I please get one right? Does the company have a viable claim against the supplier for breach of contract? A lawn service company agreed in writing to purchase from a supplier all of its requirements for lawn care products during the next calendar year. All of it? Okay. All. In the writing, the supplier agreed. It's for lawn care products, so it's goods, UCC. The supplier the supplier agreed to fulfill those requirements and to give the company a 10% discount off its published prices, but it reserved the right to increase the published prices during the year. That's a little sus. After the parties had performed under the agreement for 3 months, the supplier notified the company that it would no longer give the company the 10% discount off the published prices. You only have a viable claim against the supplier to reach a contract. Yes, because part performance of the agreement, both parties made it enforceable. Yes, because the company's agreement to buy all its longer from the supplier made the agreement enforceable. No, because the supplier could and did revoke its respect to future deliveries. No, because the absence of minimum contractual term rendered the promise illusory. No, also. That's not D. To give the company a 10% discount off its published, we reserve the right to... It reserved the right to increase the public. Can you do that? I knew it was B! Why is it not C? Revocation is relevant to contract reformation. Given the mutual assent occurred here, invalid requirements. Oh, although the supplier did reserve the right to increase the published prices, it did not reserve the right to take away the company's promised 10% discount off those prices. Can I get one right? The testimony of the attorney is the defendant is on trial for the crime of obstructing justice by concealing records subpoenaed on May 1 in a government investigation. The government calls an attorney to testify that on May 3rd, the defendant asked him how to comply with the regulations regarding the transfer of records to a safe deposit box in Mexico. The defendant is on trial for crime. The government calls an attorney to testify that on May 3rd, the defendant asked him how to comply with the regulations regarding the transfer of records to a safe deposit. That sounds privileged. It relates to conduct. Because an attorney is required to keep the confidences of his clients. What do you mean it's not privileged? When a client seeks his attorney advice and furthers planning to commit an illegal activity, the attorney-client privilege does not apply, regardless of whether... What? Oh, my... Stupid. When a client seeks his attorney's advice in furtherance of planning to commit an illegal activity, the attorney-client privilege does not apply, regardless of whether... I'm getting all of these wrong. Okay, use the brain for the next one. Should the court permit the daughter to testify about the brother's statement over the defendant's objection? A defendant has been sued for theft by his former employer. At trial, the employer seeks to call the defendant's estranged daughter to testify. The daughter would testify that her brother told her, "I helped defendant steal money from blank." The brother is available to testify but would be hostile witness. The defendant's attorney objects to the daughter's testimony on hearsay grounds. The employer argues that the statement is admissible under the statements against interest. I helped blank steal money from his employer. Okay, the statements against interest, I think you have to be unavailable. And the hostile, certainly, I think that satisfies that. Okay, I don't like. Okay, the brother is available to testify. He's not because he would be hostile. Because hearsay session, it doesn't. It applies in civil as well. Because the same exposes. Yeah, yes, but only if corroborate. I don't think it has anything to corroborate. Are you kidding me? The exception to hearsay rules are against allows hearsay is to be visible to the for just making it they would not have been. However, this exception may be used to admit evidence only after showing this the brother's available, even though he's freaking hostile. I am literally dying. Why am I doing so poorly? Hostile W is not the same as an unavailable W. Oh my god, I'm dying. Playing the tape recording for the jury would be: at the defendant's trial for theft, a witness called a prosecutor testified to the following. 1. That from his apartment window he saw thieves across the street break the window of a jewelry store, take jewelry, and leave in the car. 2. That his wife telephoned police and relayed to them the license number of the thief's car as the witness looked out the window with binoculars and read it to her. And 3. That he has no present memory of the number, but that immediately after he listened to the playback of the police tape recording, gave the license number, which belongs to the defendant's car, and verified that she had relayed the number accurately. Playing this recording for the jury would be proper. It would totally be proper as a recorded collection. A recorded recollection. It's definitely not that. It's definitely not that. Because the wife's like first-hand knowledge. Nope. She was like watching it. That's a present sense impression. Yeah, it's definitely A. Finally! The crimes below are listed in descending order of serious. What is the most serious crime the patron could be victim of? A man who had become very drunk, that's relevant, left a bar and started to walk home. Another patron of the bar, who had observed the man's condition, followed him. The patron saw the man stumble and fall to the ground near an alley. The patron then began to pull out a gun, but saw that the man had passed out in the gutter. The patron reached into the man's pocket, grabbed his wallet, and started to walk away. When the patron heard the officers approaching, he dropped the wallet and ran off. The patron. Okay, so he definitely committed larceny. The patron saw the man stumble and fall to the ground. He's followed him, so he's behind him. He passed out in the gutter, so there's no threat or perceived fear or whatever it's on. And it's not attempted robbery. The patron then pulled a gun. Why did he pull out a gun? It's not attempted larceny because he definitely committed that. Say larceny, it could be attempted robbery. Woo! Okay, why is it not attempted robbery though? The patron could be convicted of the more serious crime of larceny. Thus, larceny is more serious than attempted robbery. Interesting. Oh, because I guess it's the actual crime versus attempted. I see. At trial, the pedestrian has been unable to offer any evidence as to the exact room for which the chair was thrown. The defendants have filed a motion for a directed verdict. Should the court grant the verdict? A pedestrian was injured when hit by a chair that was thrown from an upper story hotel window. The pedestrian sued the occupants of all the rooms from which the chair might have been thrown. At trial, the pedestrian has been unable to offer any evidence as to the exact room for which the chair was thrown. The defendants have filed a motion for a directed verdict. No, because for some reason it looks like alternative liability. I don't know what that is. Yes, because the plaintiff has the burden to prove that a particular defendant's conduct is actual cause. Yes, because the pedestrian failed to offer it. Gently engaged in tortious conduct. When two or more tortious acts combine to cause an indivisible injury to a plaintiff, each tortfeasor is jointly and severally liable. Defendants in a civil suit can be held jointly and severally liable only if the concurrent acts brought about. These acts do not have to be simultaneous. Here, only one occupant threw a chair. There's no evidence that defendants all contributed to the harm. Therefore, the motion for direct. Petition must offer evidence that the defendants either jointly engaged in tortious conduct. Oh, is that because he sued all of them, so he has to show that they engage in tortious conduct. I've literally gotten only 1 out of 10 right. The buyer consulted his lawyer, who properly advised that in an appropriate action, the buyer would probably obtain title to blah blah blah. So the buyer, let's look about 25 years ago, a seller conveyed Blackacre to buyer by a warranty deed. The seller at that time also executed and delivered an instrument in the proper form of a deed purporting to convey Whiteacre to the buyer. The seller thought she had title to Whiteacre, but did not. Interesting. Therefore, no title passed by virtue of the Whiteacre deed. The seller at that time also executed. Whiteacre consisted of 3 acres of brushland adjoining west boundary of Blackacre. Oh, okay, so buyer has Blackacre, fine. Seller gave Whiteacre to buyer as well. But seller didn't actually have Whiteacre. Whiteacre consisted of 3 acres of bush land. The buyer had us occasionally hunted rabbits on Whiteacre, but less than annually. No one else came on Whiteacre except occasional rabbit hunters. 20 years ago, the buyer planted a row of evergreens in the vicinity of the opposite east boundary of Blackacre and erected a fence just beyond the evergreens to the east. In fact, both the trees of the fence were placed on Greenacre, owned by a neighbor, which bordered the east boundary of Blackacre. The buyer was unsure of the exact boundary and placed the trees and the fence in order to establish his rights up to the fence. The fence is located 10 feet within Greenacre. Now the buyer has paid his property surveyed and the title checked and has learned of the facts. The period to entire quiet time is 15 years ago. It's 15 years. The buyer consulted his lawyer. Okay, so he definitely has Blackacre. The buyer consulted to properly advised, and in appropriate action, the buyer will probably obtain title to Greenacre. So he definitely has a 10-foot strip of Greenacre, so it's not A. Because it happened 20 years ago, and the thing is 15 years. It's open and notorious, fence, hostile. Yeah. What does he get? Whiteacre. It doesn't start to run if you didn't actually have it to get. Less often than annually. That doesn't sound like continuous enough. Yeah. The virus of yeah. A dispute has arisen. Let's just keep Undertale music playing like actual, not meme. A woman. Is the brother correct? A woman owned land subject to a mortgage held by a bank. She fell behind in her mortgage loan payments, and the bank properly initiated foreclosure proceedings. The land was sold at foreclosure sale that resulted in surplus proceeds to which the woman was entitled. Before payment of the surplus proceeds, she died testate. In her duly probated will, she had executed before granting the mortgage to the bank. The woman specifically devised land to a charity. The remainder of the woman's estate was given by her will to her brother Solaire. A dispute has arisen, so who's gonna get it? Equitable, what's the thing? Equitable conversion, whatever it's called. So the woman specifically devised the land to the charity, right? And if this was the sale from the land, it should go to the charity by equitable conversion. The woman's brother contends that he is now entitled to proceeds. No, because of course that's not that. No, because the woman's clearly indicated that the charity of the land. What? Will speaks at the time of the testator's death. Oh, here before her death, the woman lost her interest in the land. Thus, at the time, I see. Rats. Ugh, we're doing so bad. Assume that the child was negligent and the child's mother did not adequately supervise the child. If the customer brings an action based on negligence against the child's mother, will the customer prevail? An 8-year-old child went to the grocery store with her mother. The child pushed the grocery cart while her mother put items into it. The child's mother remained near the child at all times. Another customer in the store noticed the child pushing the cart in a manner that caused the customer no concern. A short time later, the cart the child was pushing struck the customer in the knee, inflicting serious injury. Soon the child was negligent, and the child's mother did not act. If the customer brings an action based on against the child's mother, will it prevail? Oh, they're all yes. I was thinking no, but okay. That's not how that works. It's more so on that, because I don't think parents are actually liable for their kids' torts. Yeah. Parents have a number of affirmative duties based. Parent who's physically present and fails to exercise control of the child is vicariously liable. Is generally not vicariously liable for the child's torture, rather than liable for their own negligence in failing to control the child. Yeah, that makes sense. Has a retailer properly demanded a jury trial? A retailer bought a federal diversity action against an architect alleging the fraudulent misrepresentations in the architect's design of the retail store. The complaint did not include a jury demand, right? Alleging fraudulent misrepresentations. Okay, what kind? Is that equity? Is that monetary? I don't freaking know. The architect timely moved to dismiss the action for failure to state a claim. He did not file an answer. 20 days after being served with the motion, but he didn't file an answer, so that's important. 20 days after being served with the motion, the retailer amended the complaint to add defamation claim based on the architect's recent statements about the retailer in a local newspaper. In the amended complaint, the retailer demanded property. Yes, it's fine because it's within 14 days of the last thing that addresses the complaint, and he hasn't filed an answer yet, so that 14-day timer hasn't started ticking. And the what's it called? The defamation, that could be what's it called? You don't get jury trials on equitable things. Defamation is not an equitable thing. Has a retailer? Yes, but on the because the original complaint did not contain. No, it's not there. Yes, on both claims because I had not answered the original complaint. Yes, it's that. Yes, I'm so smart. How did so many people get that one right? It doesn't feel good when I get the few that I get right are the ones that everyone gets right. The plaintiff's testimony concerning the woman's statement is: a plaintiff sued a defendant for breach of contract. The plaintiff's position was that the woman, whom he understood to be the defendant's agent, said, "On behalf of the defendant, I accept your offer." The defendant asserted that the woman had no actual apparent authority to accept the offer on the defendant's behalf. The plaintiff's testimony concerning the woman's statement is: a plaintiff sued. The plaintiff's position was that the woman whom said, yeah, it's admissible. It's admissible. Upon or subject to introduction of evidence sufficient to support a finding by the jury that the woman had actual. See, what the heck are these two even saying? Admissible provided that the court first finds a preponderance of evidence that the woman had actual. No, because I think it's B. Yes! There's no requirement. Yeah, okay, yeah, the preponderance thing was like not making sense to me. I hate when they're like worded. Oh, and that's just saying if it's relevant, isn't it? The patient sued. Okay, should the court grant the hospital's motion? Patient sued the improper maintenance of the doors. Patient has produced evidence. Has produced no evidence of a specific conduct or neglect on the part of the hospital that would cause automatic doors to function. Okay, here we go. A patient in a hospital was placed in a wheelchair with his broken leg extended straight out in front of him. As a nurse employed by the hospital was pushing the wheelchair through the set of automatic doors at a normal pace, the doors closed on the patient's foot, injuring it. The nurse attempted to pull the wheelchair back through the doors. This action caused the doors to close more tightly on the patient's foot, injuring it further. The patient sued the hospital, alleging improper maintenance of the doors. The patient has produced no evidence of specific conduct or neglect on the part of the hospital that would have caused the automatic doors. Possible doesn't move for summary judgment. Should the court grant the host? No, because it could have been yeah, raised. Yeah. I think my problem is that like when I think I know the answer, I click it immediately, but like I don't read all of them. Like I got it right here, but I probably should have read all these other ones first. Is the appeal proper? A scientist domiciled in state A brought a federal civil action against his former employer, a company incorporated in state A, alleging retaliatory discharge under federal and state law. Okay, seeking damages under federal and state law. It's a federal question. The company moved to dismiss the federal claim, and the court granted the motion. The court's written order read in entirety. The company's motion to dismiss the federal claim is granted. The scientist immediately appealed this decision to the Court of Appeals. Is this appeal proper? Because usually you can't appeal unless there's like a final order, but this one says the company's motion to dismiss the federal claim is granted. That's not, you can like, the federal court can say parts, like one part of the claim is dismissed and the other part isn't. And I think what it says right here, like it kind of like severed it. That's not like the exact way to say it, because severed means something else. So I think it's that. I don't know what an interlocutory appeal is. Oh, you've got to be kidding me. Why is it not D? It's not final until all claims in the action have been resolved. Okay, I didn't know that. Final judgment rule. I'm freaking losing my mind. A judgment is not final until all claims in the action have been resolved. I didn't know that. A party can ask the court to certify a final judgment as to a resolved claim when it is separate and distinct from unresolved claims. Okay, that's what I didn't know. However, FRCP 54B lets a party ask the court to certify a final judgment as to a resolved claim when it is separate and distinct from the unresolved claims, and then appeal that decision. Oh my god, I'm doing so poorly, dude. May the president constitutionally remove the director without the Senate's consent. In a response to a nationwide increased drug-related crime, Congress passed a statute creating a new agency responsible for enforcing federal laws. The statute authorizes the president to appoint the agency's director with the advice and consent of the Senate, and prohibits the president from removing the director without the Senate's consent. The president appointed a director, and the Senate confirmed the appointment. Recently, the president has become dissatisfied with the director's strict approach to drug law. Because a majority of senators favor drug strict enforcement, the Senate has refused to consent to the director's removal. I think he can, because the appointments clause lets him like. Yes, because congressional participation decision to remove a presidential appointee violates the separation clause. Yes, because Congress cannot limit the ability of the president to remove any employee from the executive branch. I don't like the word of any. Okay, yeah. Sometimes when they say like really definitive like words like that, it kind of throws me off. The Supreme Court has repeatedly held that Congress shall not play any role in the removal of executive officers. This is an overbroad statement. Congress has the power to remove certain types of federal officers, such as those serving as members of the governing bodies of regulatory agencies and inferior agencies, and where the head of the agency may be removed by the president. However, under the separation of powers doctrine, Congress may not play a role in the presidential appointee. Okay, yeah. Congressional participation in the decision to remove a presidential employee violates. Okay, yeah. If the logger is sued for the breach of contract by the landowner's next-door neighbor, whose view of nearby lake is obscured by the standing timber, the neighbor will probably... A landholder was land rich by inheritance but money poor, having suffered severe losses on bad investments but still owned several thousand acres of unencumbered timberland. He had a large family, and his normal fixed personal expenses were high. Pressed for cash, he advertised a proposed sale of standing timber on a choice 2,000-acre land tract. The only response was an offer by a logger, the owner of a large integrated construction enterprise, after inspection of the advertised tract. The logger offered a fair price of the timber rights in question, and the landholder accepted the offer. The 2,000-acre tract was an abundant wild game habitat and had been used for many years with the landholder's permission by area hunters. The logger's performance of the timber contract would destroy the habitat. Without legal excuse and over the landholder's strong objection, the logger repudiated the contract before commencing commerce. The landholder could not afford to hire a lawyer to take legal action, and made no attempt to assign any of the cause of action he might have had against the lot. If the logger is sued for breach of contract by the landholder's next-door neighbor, whose view of a nearby lake is obscured by the standing timber, the neighbor will why the heck? Lose. That was a stupid question. The buyer brought an appropriate action against the seller for breach of contract, for which party is the court likely to find. A buyer and seller entered a contract for the sale of an identified parcel of land. The contract expressly provided that the buyer was to pay $150,000 in cash and the land at the time of the closing, but did not state the closing date. The parties had not agreed on the closing date because the buyer was not sure at the time the contract was signed how he would raise the cash. 15 days after the contract was signed, the seller learned that he could sell the land to a third party for $200,000. The seller asked the buyer if she would agree to rescind the contract. The buyer refused. The seller then told her that he would not complete the transaction, contending that the contract was unenforceable under the statute of frauds because an essential element, time and performance, was not agreed upon by the parties and was not expressly stated in the agreement. The seller sold the land to a third party. The buyer brought an appropriate action. You may have a point about that. Did not state the closing date. Why would he be unjustly enriched? No, not time of the essence. I don't like how B says. Okay, I guess it is. While the lack of an essential element may sometimes implicate statute of frauds, there is no rule requiring the parties to contract for the sale of property to agree in writing to the timing of performance. The court will inform the performance is within a reasonable time. That one I need to know, unfortunately. For statute of frauds, you don't have to have an exact closing date for it to be valid. Courts will assume performance within a reasonable time was intended. This is all learning opportunities, honestly. Even though we're getting like a bunch wrong, it's all a learning opportunity. Which of the following best supports the airline's defense based on the First Amendment? I'm such a genius at the First Amendment. A state law imposes penalties for any public statement containing false or misleading information about a service or product. An airline falsely claimed in an advertisement that its competitor had an inferior safety record. The claim was based on erroneous information found on the website of a non-profit consumer advocacy group that the airline assumed to be true. The airline was charged under state law for making a false statement. No federal statute applies. What is the best support in which of the following best supports the airline in a defense based on the First Amendment? It was made without actual malice. No, I don't think any public statement containing false or misleading info about a service or product. The statement about the safety record was protected non-commercial speech. That comes with like defamation, actually. It was charged under the state law for making a false statement. Oh, just for making a false statement? It might be overbroad. In an advertisement, though. No, but it definitely is commercial speech because it's an advertisement. So the state law's overbroad. Woohoo! Process of elimination, baby. The overbreadth of the law is the best argument. State law is not. Yeah, okay, yeah. That it has to be actual malice, by the way. Government may regulate certain types of non-commercial speech. Yes, they may. Rules around prior restrictions don't apply here because the statement was already made by the airline. Yes, it was. Ugh, I hate when questions are like 3 paragraphs. If no federal statute is applicable, which of the following facts if proven, would most strongly support the validity of the action in the reapportionment board? The Constitution of a state authorizes a 5-member state reapportionment board to redraw state legislative districts every 10 years. In the last state legislative reapportionment, the board, by a unanimous vote, divided the greater metropolitan area composed of a large city and several contiguous townships into 3 equally populated state legislative districts. The result of the districting was 40% of the black population resided in the districts, 45% of the area's total black population resided in the second of those districts, and 15% in the third district. I see where it's getting at. A registered voter who is black and is a resident of the city brings suit in an appropriate court against the members of the state reapportionment board, seeking declaratory and injunctive relief that would require the boundary lines of the state legislative districts in the greater metropolitan area to be drawn. His only claim is that the current reapportionment violates the 15th Amendment because it improperly dilutes the voting power of black residents who reside in that area. If there's no federal statute, which of the following facts, if proven, would most strongly support? Okay. I think, okay, well, let's see. I'll say what I think afterwards. Which support the validity, would most strongly support the validity of the action of the state. Oh, okay, so like, what would, in drawing the current district lines, the reapportionment board precisely complied with state constitutional requirements that the state legislative districts be compact and follow political subdivision boundaries to the maximum extent feasible. The reapportionment board was composed of 3 white members and 2 black members, and both of the board's black members were satisfied that its plan did not improperly dilute the voting power of the black residents who reside in that area. Although the rate of a voter registration among blacks is below that of the voter registrations among whites in the greater metropolitan area, 2 black legislators have been elected from that area. The total black population in the greater metropolitan area amounts to only 50% of the population that is required to comprise a single legislature. Okay, I don't like any of these, I'm gonna say. Yeah. Not exactly sure why it would be that one, but... brief explanation. An alternate reason for redistricting one does not involve race as a predominant factor. Oh, okay. Which standard of review applies to the argument? A student at a private university sued the university in federal court for negligence after he fell from a scaffolding in a university-owned theater building. At trial, after briefing from both parties, the court permitted the jury to hear testimony that there had been several previous accidents in the same building. The jury found for the student, and the university appealed. One of the university arguments on the appeal is that the testimony about the previous accident should have been excluded as irrelevant and highly prejudicial. It's not de novo. It's not harmless error. Why is it not clearly erroneous? Determining the relevance of evidence is within the trial court's discretion. Therefore, the argument will be reviewed using abuse of discretion. An appellate court applies a clearly erroneous standard when reviewing findings of fact. Ah, okay. De novo is also an appellate review, right? Evidentiary ruling involving the application of the act, i.e. Oh, de novo's for law, clearly erroneous is for facts, and abuse of discretion is for, I don't know, everything else, I guess. What would this under be? Evidence, I guess, or Civ Pro? What does it say? It's under Civ Pro. Abuse of discretion is used for determining the relevance of evidence. It's for discretionary findings. Rulings. Like evidentiary or discovery rulings. And then clearly erroneous is used by the appellate court for lower court fact finding, and then de novo is used for lower court issue of law, not fact. I'm getting bored. I'll do two more. There's no statute dealing with the conveyances to dead persons. Title on Blackacre is now in. The owner of Blackacre had promised his best friend that if at any time the owner decided to sell his summer cottage property known as Blackacre, he would give his best friend the opportunity to purchase Blackacre. At the time when the best friend was serving overseas in the United States Navy, the owner decided to sell Blackacre and spoke to his best friend's mother. Before the best friend sailed, he had arranged for his mother to become a joint owner of his various bank accounts so that she would be able to pay his bills while he was gone. When she heard from the owner, the best friend's mother took the necessary funds from the friend's account and paid the owner $20,000, the fair market value of Blackacre. The owner executed and delivered to the best friend's mother a deed in proper form, according to convey Blackacre to his best friend. Okay, so even though it's to his mom, it's to his friend, because it's intent and delivery. The mother promptly recorded the deed. Shortly thereafter, the mother learned that the best friend, her son, has been killed in an accident at sea 1 week before the delivery of the deed. The best friend's will, which was now duly probated, leaves his entire estate to the First Church. His mother... Okay, so who's getting his mom or the church? Okay, the owner executed and delivered the best friend's mother a deed conveying Blackacre to his friend. And mother recorded. Her friend. The best friend, her son, had been killed in an accident at sea 1 week before the delivery of the deed. He's not even alive. Oh, and it speaks to his death, right? His estate to his church. I think residuate would be to his mom, right? Best friend's mother. Deeds cannot be delivered to the dead. Well, I didn't freaking know that. Deeds cannot be delivered to the dead. Alright, I think I need to watch this video, so I'm just gonna end it here. We did terrible!